welcome back. We're still covering the Robert Kraft case, that being the suppression hearing as to whether or not the police obtained video surveillance of the massage parlor come in. We want to now switch gears to the Georgia v. Tiffany Moss case. Now, if you recall, she received a guilty verdict where she'd be sentenced to the death penalty. Let's take a look at that verdict. There you hear it, the judge reading the verdict and also the decision from the jury recommending the death penalty. We have here with us Michael Mears, or Mike Mears as he likes to be called. Mike, how you doing today?
That's fine. Glad to be here.
Good. Now, Mike, I had the honor and the privilege of reading one of your articles about the life after hearing that, after hearing that you're going to be sentenced to death. Now, I practice in a state that doesn't have the death penalty, so please, not only enlighten me, but also our viewers as to what's life going to be like now for Tiffany Moss going forward.
Well, since she's the only woman on Georgia's death row, she will be held in almost solitary confinement. She will have some contact with other inmates, but very limited. Georgia does not have a separate death row for women because we've only had 6 women sentenced to death in Georgia's history. So Miss Moss will be at a prison, a women's prison in North Georgia, but she will be isolated from all other inmates, primarily for her own safety, but because she is under the sentence of death, she will get special scrutiny. She'll have access to visitors on a limited basis. She'll have access to reading material and some limited television. But pretty much she's going to be on her own in a one-person cell until this sentence is carried out or is reversed.
Understood. Now, let's jump to the judge actually imposing the sentence when it was handed down to Tiffany Moss.
Is there anything that you'd like to say before I impose sentence, ma'am? Ma'am, with respect to count 1, the jury has found you guilty of murder and other counts contained in the indictment against you. They have considered the circumstances surrounding that murder and found that aggravating circumstances exist. With respect to count 1, ma'am, I impose the sentence of death. Counts 2 and 3 are vacated by operation of law. They're felony murder charges. Counts 4 and 5, the cruelty charges, of course, merge. With respect to count 6, I impose a 20-year sentence to be served in confinement, ma'am. With respect to things that you should also be considering, ma'am, you should understand that the law requires that the date of execution be scheduled by the court at this time. OCGA section 171034 requires that the court set the date of execution not less than 20 days nor more than 60 days from today's date, and there's a 7-day window within which the execution is to take place. I fix the date of your execution, ma'am, as the 7-day interval between noon on June the 7th, 2019 and noon on June the 14th, 2019.
So there you have the judge reading the sentence or imposing the sentence to Tiffany Moss. Now, Mike, you were saying that the life that she's going to be living is a very solitude one. She's going to be sectioned off. I know that this process, they always say it takes a very, very long time. Can you give us in terms of months or years, when will this sentence be imposed, and is there a possibility that the death sentence might not actually happen?
It's possible. In Georgia, whenever a person, male or female, is sentenced to death, the Georgia Supreme Court automatically reviews that trial and the imposition of that sentence. Whether the defendant wants to have an appeal or not, it's not up to them. The Georgia Supreme Court will review the trial transcript, the trial record, all of the evidence that was submitted in the case, and render an opinion either upholding the sentence of death, the conviction and sentence of death, or reversing it, sending it back down for further proceeding. In this particular case, Ms. Moss presented no evidence whatsoever. She did limited involvement in the jury selection, but once the case went, the prosecution started presenting its case, she asked no questions, she put up no evidence. So the record in the case is going to be only what the prosecution has submitted. She declined to have attorneys represent her, and however, the Georgia standard for representing yourself is quite low. All you have to know is what you're charged with, what the penalty is if you're convicted of that offense, and you know what a lawyer's for if you want one. She's passed all those tests already in pretrial proceedings. So the Georgia Supreme Court will be looking to see if there were any errors committed during the course of her trial. That will probably take anywhere from 6 months to a year because it's going to be, the transcript has to be prepared, it has to be transmitted. Even though the judge set a particular execution date as he's required to do, once the Supreme Court gets the case on appeal and for review, that sentence will be stayed until the final the final decision is made. Once that decision is made, all appeals are voluntary, and unless Ms. Moss decides to appeal through a habeas corpus proceeding or to federal court, the sentence could be carried out within a year or a year and a half.
Now again, this is just my not knowing the process. Are these appeals automatic, or does Ms. Moss have to put in a petition for them? Will she be assigned counsel to do this for her? And I guess the question is, if she's assigned counsel, will she continue her right to be represented pro se or by herself? Will that add to the calculus of whether or not there were any errors here for the appellate department?
Since she was representing herself, she will not have counsel representing her at the first appeal to the Georgia Supreme Court. That's automatic. Georgia is a unique state. We do not provide counsel for individuals after they've been sentenced to death and after they have finished their direct appeal to the Georgia Supreme Court. So if she were to decide to appeal, assuming that the Georgia Supreme Court upholds the sentence of death, before she could go into habeas corpus proceedings, she'd have to find volunteer lawyers or have to try to do it herself. The state of Georgia will not provide her counsel after this appeal goes to the Georgia Supreme Court. So she's going to be on her own.
Yeah. So I guess just because I come from a place, I practice in New York, so it's almost mind-boggling that you won't have representation with you at every step of the way. But I know that you also mentioned in your article that I'm kind of cheating a little for our viewers, that the Georgia State Board of Pardons and Paroles actually has a role to play in this. When would they step in, and based on your calculus, how do you feel that they might rule in a situation where someone's pro se and they put on no witnesses, they did no cross-examination? Is this just we're all done here, or is there something to dive deeper into?
Georgia has a Board of Pardons and Parole that is the final arbiter of whether or not any sentence is carried out, commuted, or set aside as far as the death penalty is concerned. The governor, no one else has any say-so about it. The Board of Pardons and Parole will only act in a clemency proceeding once all of her appeals have been exhausted. In this case, unless she decides to go into federal court or to file a habeas proceeding, that time will come when the Georgia Supreme Court issues its final decision. Once that final decision has been issued by the Georgia Supreme Court, assuming that they uphold her sentence of death, then at that point, the Board of Pardons and Parole will conduct a clemency hearing. That hearing is behind closed doors. People can put up witnesses if they choose, but that's usually done with the assistance of counsel. Assuming she has not hired counsel or does not have volunteer counsel, the Clemency Board or the Board of Pardons and Parole will simply review the facts that have been presented. It's very rare in Georgia for the Board of Pardons and Parole to commute a death sentence. It has been done, but it is a very rare instance when you see the Board of Pardons and Parole stepping in to grant relief in a particular case. These members are appointed by the governor for 7-year terms. They're politically untouchable, so to speak. And so they're not swayed by public opinion. They're not swayed by anything other than the facts of the case. And in this particular case, it's going to be tough, in my opinion, for them to exercise any sense of clemency from Ms. Moss, assuming that the Supreme Court upholds her sentence.
Yeah. From what you've seen in past clemency, is there some sort of calculus or some sort of rubric that you can glean that says, I've seen them have clemency in these 2 or 3 cases, and this is what I can see they're looking for? And if there is that kind of metric, do you see that here in the Tiffany Moss case, or is it kind of absent because no one was really cross-examined and no evidence was brought?
Yeah, I don't see any of the usual factors that a clemency hearing would act upon. Like I said, it's very rare. And what the clemency board, the Board of Pardons and Paroles, looks for, is there something redeeming about this person that surpasses the fact that they had a fair trial? Is there something about this person's background that would cause the state to step in and grant some relief? Quite frankly, I'm opposed to the death penalty, but I don't see anything here that would cause the Board of Pardons and Paroles to grant her relief. Her only hope is going to be if the Georgia Supreme Court steps in and grants relief by vacating her sentence of death and demanding a new trial. Again, I don't see that happening either, because the district attorney that tried this case, Mr. Porter, did a very thorough job in making sure that her rights were made known to her and that she was afforded every opportunity. Matter of fact, this case went to the Georgia Supreme Court just before the trial started on the issue of whether or not she was competent to represent herself. Georgia Supreme Court says she was. So that takes away a big issue right there. You didn't ask, but I have to say, I think that Ms. Moss was trying to get this jury to sentence her to death. She asked no questions. She did not present any evidence. She made no effort whatsoever to sway this jury in any way. It's called suicide by jury. You've heard the expression suicide by cop. This is another variation of that. In my opinion, Ms. Moss was asking this jury to help her commit suicide.
Yeah. And unfortunately, I agree with everything you're saying, that it's kind of a sad reality that she didn't put on a defense. But we're going to get more information from you, Mike, as we come back after these breaks. So there you have that lawyer who's kind of on the side stepping in and saying that she should receive representation during the penalty phase. Well, Laura, to you, as a lawyer, I mean, you're kind of stepping in and saying, hey, I believe in representation. This person needs it even if they don't ask for it. I mean, how do you juggle that, I guess?
I think that this is a perfect example of why it is so difficult to be a judge and why it is so difficult to practice criminal law in jurisdictions where there's the death penalty. Because we have these questions that are incredibly difficult to answer. And one of them is, look, when you have somebody that wants to proceed pro se, are there circumstances where we basically won't allow it? And you know, the right to proceed with the counsel of your own choosing, even if that choice is not to have an attorney and to simply represent yourself, is something that we have a right to do. Every defendant has that right. And essentially, even though I think it looks like in this case we are giving this person an additional safeguard, in doing that, we're also taking away some of her freedom to choose what she wants on her own. We're superimposing our judgment on what would be best for her, for what she would want. And I think that, of course, in a situation where the penalty is death, you know, everyone is proceeding with, you know, kind of the best intentions. We want this person to have the fairest proceeding she could possibly have. But I think that there are very different philosophical ideas of what that fairness actually means. And that's precisely why the death penalty is such a difficult thing to work with, because you could have reasonable and dedicated people that have opposite opinions about what fairness actually requires in this case.
Yeah. And Mike, to use your term, you're saying that there is death by cops, and this might be a situation of death by prosecution. As a lawyer is saying, and I agree, like, here we are imposing our will and our view that this person needs representation, but if their decision is to go down this route on their own that we might see as destructive, it again comes to the question of balancing rights and interests of the individual. How do you see this play out in your practice, Mike, or in your area of expertise?
Well, I've seen similar circumstances before, and the courts have always come down on the right of the individual to exercise their right to represent themselves. The Sixth Amendment right of counsel is one of the more sacred rights we have, particularly when you're talking about the death penalty. However, the U.S. Supreme Court and the courts here in Georgia have consistently said that the right to represent yourself, as long as you're competent, and the competency is, do you know what the charges are? Do you know what the penalty is if you're convicted of those charges? and you know what the role of the lawyer is. Once that question has been answered affirmatively, the courts have been very, very strong in safeguarding an individual's right to make their own decisions, whether it's foolish, whether it's suicidal, as it may well be in this case. The courts have come down on the side of letting an individual represent themselves, even to their own detriment.
Exactly. And as a public defender, not to bring myself into this, we've had many situations where you have a client and you want to represent them and they say no, they don't want your representation. And if you're represented by a public defender, by definition, you don't have the means to pay for a lawyer. So oftentimes you have this person out on their own. And to Mike and Allura's point, I think it's correct. You have to strike the balance between individual rights and that of imposing someone else's will onto that individual. And I think here, you both allude to great points that balance needs to be made, and maybe after this motion, Tiffany Moss would not be represented by a lawyer, but instead be represented by herself during the death penalty phase. I want to see what we have coming up next. Mike, just briefly talk about, if you can, what that penalty phase would look like. And if she did have representation, what would that look like for her?
Under Georgia's death penalty statute, as most other death penalty statutes, the state must prove that the murder was committed along with an aggravating circumstance. Georgia recognizes 10 aggravating circumstances, everything for murder for hire, murder for pecuniary gain, or in this particular case, what we call the B7 aggravator, which means that the murder was outrageously, wantonly vile and inhumane, and that it involved torture. Once the prosecution has proven that at least one of those 10 aggravating circumstances exist, then the defendant has the right under Georgia law to present what is called mitigating circumstances, or reasons why the jury should not sentence the person to death. It could be mental illness, it could be brain damage, it could be a bad upbringing, it could be nothing more than a plea for mercy, which I've seen. And the defendant has the right to ask the jurors to balance the aggravating circumstance against any mitigating circumstance. Georgia will allow a defendant to put up anything that they think is mitigating. There are no statutory mitigating circumstances required. So Ms. Moss, had she chosen to do so through herself or through her attorneys, could have put up almost anything in mitigation to get the jurors to understand that the death penalty should not be imposed. But since she did not put up any mitigating evidence, and the attorneys were not allowed to step in and do it on her behalf, all the jury had before it was the details of a very horrific, wantonly vile murder. And so there was very little. Now, the jury could always come back and sentence her to life in prison, life without parole, on their own. But jurors like to have the evidence as to why should we do that. They didn't hear that in this case. But again, I'll say that the Georgia courts have been very strong in their support of a defendant's right to represent herself whenever she exercises that right competently. And it appears that Ms. Moss knew what the charges were, knew what the penalty was, and she chose to go forward. Again, I have the opinion that Ms. Moss was attempting to commit suicide by jury. She wanted the jurors to sentence her to death. I may be wrong. I hope I'm proven wrong, but I think the courts are going to look at her inactivity as a decision she made on her own, and she'll have to live with the consequences.
Mike, I don't think there's any more we can add to that insight. Mike, I believe that you're leaving us now, so thank you for your final words. I hope you come back when you get another chance. If you guys don't forget, come back. Allura and I will still be talking here on Law and Crime Trial Network after this break.